SJC-11819, Commonwealth v. Andre R. Brewer.
It's okay.
Thank you, Fran.
Good morning, Your Honors. May it please the Court, Leslie O'Brien for Andre Brewer. The question raised in this case is whether and under what circumstances a judge may grant defense witness immunity. The Court has already stated that in some circumstances, due process may require that a judge grant a limited form of immunity. I'm referring, of course, to the recent Batcher case and the Pixley case that is cited in Batcher.
What would a limited form of immunity look like?
Well, that's exactly that's one of the things I've been struggling with in preparing to argue here today. And I'm getting ahead of myself a little bit, but what the question that I was grappling with is that since the Court has already said that Article 12 requires transactional immunity, right, where a witness is being compelled by the prosecution to testify, what would this limited form of immunity look like in the context of judge granted immunity for a defense witness? And the distinction, what I realized is that the distinction is, and certainly the distinction in this particular case, is that we don't have a situation where the prosecution is compelling someone to testify so that transactional immunity would be required. What we had in this case, and I think what might occur in many cases, is that you have witnesses coming in, they're willing to testify for the defense, they have something useful to say for the defense, but for the fact that they are concerned about incriminating themselves on particular grounds. So that if the judge if the judge can weigh the interests and fashion a form of immunity that satisfies the witness, and the witness is willing to testify with a limited form of immunity, then it would seem to me that solves the balance of interests here. For instance, Mr. Stewart's...
But isn't it still compulsory process?
It's...
Suppose the witness doesn't want to do it.
Well, if the witness doesn't want to do it, then this wouldn't work. This limited form of immunity that I'm suggesting wouldn't work. And I think if the witness is unwilling, then you're back to there must be probably must be transactional immunity, and you have a different type of analysis. So that perhaps you're looking at a situation where that might be appropriate only where there's been a showing of extreme prosecutorial misconduct, something along those lines.
But if there was a showing of extreme, maybe this is what you're saying, prosecutorial misconduct, that sort of fits within the Vasher realm,
Yes.
Doesn't it?
Yes, that fits within Batcher. That fits within what the Court had to say in Batcher. And I'm pointing out that really what the debate here has centered on is not whether the Court not whether a trial judge would ever have the authority to grant judicial immunity to a defense witness. What the debate has centered on is when that would be justified. Now, in Batcher, the court stated that prosecutorial misconduct would be such a circumstance, and so the debate here has centered on, well, could there be something less, something other than actual prosecutorial misconduct that might justify a trial judge in granting immunity? And what I've suggested is that it's the circumstances have some similarities to the Brady situation, where evidence is suppressed through actions of the prosecution. And when the court looks at that, the court doesn't look at solely, well, is there deliberate misconduct by the prosecutor? Instead, the court looks at, the court will weigh the importance of the evidence that's been suppressed to the defendant. And I'd suggest that a similar type of analysis could work here.
But
of course,
one difference, of course, I think, is that with respect to Brady, you're talking about evidence. Here you're talking about if you grant immunity, if the court grants some form of immunity, it is really then, if not foreclosing, certainly hampering the prosecutorial discretion whether to bring a case against that witness or not for whatever it is that he or she is testifying about. I mean, is there a separation of powers issue that comes up with that as opposed to the Brady situation?
there is a separation of powers issue, Your Honor, but I'd point out that the courts frequently act as a check on the ability of the prosecutor to prosecute whomever the prosecutor chooses for whatever crime. And this arises frequently. It arises, for example, when the court suppresses evidence to protect Fourth Amendment rights or Article 14 rights. It arises when the court pierces the informant privilege, because very often that will force the prosecution to move to dismiss its case rather than pierce the privilege. It arises perhaps most dramatically when the court, when a trial judge grants a motion for a required finding of not guilty to protect due process rights. If the court decides that sending this case to the jury is in violation of the defendant's due process rights, then the trial judge will grant a motion for a directed verdict of not guilty.
Can I just, though there was a point that was made that I've been thinking about. It seems to me that when the prosecutor asks that a witness be immunized, the prosecutor has gotten some proffer ordinarily from the witness and knows what the witness is going to say. But it could be very worrisome. I mean, how would that work? How would you know what the witness is going to say and would be given immunity in connection with such testimony? Well, I mean, it could really be just about anything, and it could be getting immunity and then acknowledging that they committed the crime for which the defendant is standing trial and won't be prosecuted for that because they've been immunized.
Yes, and I mean, I see that as a theoretical possibility. It seems so extreme. It almost seems like
well, okay, don't go that far. But how do you know what the limits of the witness's testimony could be?
Well, that's exactly what I was grappling with when I looked at what the court had to say about limited immunity in Batcher, and just grappling with how that would work. For example, if I could back up just a tiny bit, it's said in some of these cases that the Third Circuit case Quinn is an example, that the judge really isn't in a position to evaluate the prosecutor's interest in granting immunity. But in some cases, and I think this case might represent a typical type of circumstances where the judge would have a great deal of information about what the party's interests are. In this case, the prosecution had already put its case in. The judge had held Martin hearings. The judge knew, at least to an extent, what the witnesses' concerns were. So the judge was in a particularly good position to weigh the interests of the parties. And so what I'm suggesting is that it might be, and I really didn't know what the court meant by this limited form of immunity, but it occurred to me that what the court might be saying is that the trial court could grant immunity for what it knows to be the witness's concerns. In the case of Mr. Stewart, what his attorney said when he was called upon, when he was first called before the judge, his attorney said that his concern was having previously made conflicting statements. So maybe the concern there was that he would perjure himself, that he would expose himself to perjury. Now, if the judge could frame a form of immunity where it's limited to the witness's concern that he would be prosecuted for perjury, and now the witness is willing to testify with such a guarantee that he's not going to be prosecuted for that crime, now you have a willing witness, it seems that all of the balance is now in the defendant's favor, because it doesn't affect the prosecutor's ability to prosecute this individual for perjury. And the reason I say that is the only way that the prosecutor could only prosecute for perjury if the witness takes the stand without immunity. If the witness is guaranteed immunity from prosecution for perjury, now the prosecutor is in exactly the same position. He can't prosecute this witness for perjury. So the prosecution loses really nothing in terms of the ability to prosecute, but the defendant gains his ability to put on his defense.
Well, the prosecutor loses the ability to prosecute the witness for murder if the witness gets up and says, gee, I did it.
Well, that would be only if, the witness had been granted a wider form of immunity. I'm suggesting that what the court has suggested, a limited form of immunity, can solve the difficulty here by limiting the grant of immunity to the witnesses concerned. If the witness is now satisfied with that, these witnesses are represented by counsel. If the witness and his counsel are satisfied with that type of immunity, and the witness is now willing to testify, it doesn't harm the prosecutor. It helps the defense.
If I'm understanding your example correctly, if Mr. Stewart's problem was a fear of perjury, and you're saying, okay, no prosecution for perjury, so
based on this testimony.
Based on his testimony, I mean, the prosecution has lost something, because if he wasn't going to testify because he was worried about being prosecuted for perjury, from the prosecution's point of view, if you take the prosecution's point of view, which I would think would be that whatever he said in the was it in the grand jury? I don't know.
It's not clear from the record. All it says is that he made conflicting statements in the past.
Wherever, I take it the prosecution's point of view would be that whatever his conflicting statements, his prior statements were correct, were the truth, and what he's going to testify to at trial isn't the truth. And now they can't prosecute. So he's testified, but they can't prosecute. Isn't that the way it would work?
Well, no, because he wouldn't testify if he's not satisfied with the offer of immunity. If he can't get immunity, he's not going to testify.
Right, I understand that.
So the prosecution has no case.
Well,
and
they have because they wouldn't have his prior statements either. That's what you're saying.
They don't have the two conflicting statements that they would need.
They'd just be able to get in the grand jury testimony, or not?
It would, if they only had the conflicting statement, and they don't have a conflicting statement made at trial because the witness.
No, they couldn't prosecute unless he testified at trial.
That's what I'm saying.
But I mean, they could still get in his grand jury testimony, couldn't they?
I don't know. I don't have the rules
So
regarding that.
if the witness testifies and commits perjury in that testimony, having been granted immunity, then the witness can't be prosecuted for perjury.
The witness can't be prosecuted for perjury, and the witness would not have been able to be prosecuted for perjury if he refused to testify because he had no form of immunity. So the prosecution is in the same position. That's what I'm saying.
Maybe I misunderstand. I thought anyone who is given immunity and compelled to testify can indeed be prosecuted if their testimony is false. That's the one thing they're not immunized against.
Well,
just wrong.
So that what I'm saying is that there could be a specific, this limited form of immunity that the judge has referred to in Batcher could be tailored to allow the witness to testify. And if the witness is willing, it solves this difficulty. It doesn't allow anybody to confess to murder with impunity. It's
this judicially created immunity would immunize a person from giving perjurious testimony, and which is inconsistent with anything a prosecutor, the kind of immunity the prosecutor would give.
Well, I think that would be assuming that the trial testimony would be perjurious, which that wouldn't be the certainly wouldn't be the. It may be that the witness previously said, "I didn't see anything. I don't know anything." Now the witness is willing to come forward and say the defense witness is lying.
All right. Thank you.
Thank you, Your Honors.
Good morning, Your Honors. Robert Thompson on behalf of the Commonwealth. Your Honors, in some of the presentations here and some of the amicus briefs, there's been a sort of a false starting point that's brought here, and that's the idea that somehow the prosecution is responsible for some exclusion of evidence in this case. That simply is not the case. What happened here was these witnesses asserted a valid, by all indications, a valid privilege against self-incrimination, and that's what made them unavailable. Unlike a case, for instance, in Brady, where the Commonwealth has somehow failed to disclose material it already has in its possession, what is going on here is that the unavailability is done exclusively by the witness's assertion of the privilege. What is going on here is the prosecution either being asked or being propelled, either being asked to agree or being compelled to agree to go further and take steps to make evidence available that is already unavailable to the defendant.
Right. But, I mean, let's just take the witness. It's not Mr. Stewart, the other witness that we're talking about.
Nimhart? No, not
Nimhart.
Verdu.
Verdu. So his testimony, at least as I understood from the briefs, is in some respects directly contrary to what it was that the trial witness testified to, whose name begins with an E, I think.
Ingram.
And he was the immunized trial witness.
Yes, the immunized trial witness. So to the extent, and I know you argue about whether it's basically a collateral point, I understand that, but let's say it's really central, that what Verdu would have testified to was directly contrary to the central tenet of Mr. Ingram's testimony. I appreciate what you're saying, but it does seem as though there's an unequal balance there, that because the defense cannot get that witness to testify.
Your Honor, if there was prior statements by a witness that did go to the essential point here, in other words, who did the shooting of the victim in this case, if there was prior testimony that someone else other than the defendant did that shooting, then the defendant's rights are already protected in the Commonwealth by the third-party culprit allowance of the hearsay statement of the hearsay prior identification of the third-party culprit. There's no need for immunity in that situation, Your Honor.
So in this, well, except it's somewhat different from having the actual witness than having somebody testify that he told me that, correct?
And being then subject to cross-examination and challenge, which of course they wouldn't be with the hearsay statement. Your Honor.
But all right, even putting that aside, you could say in this case that you may characterize the contradiction as somewhat collateral, but it really may go to, when you take it all, it may go very much to whether a jury's going to believe your witness or not.
Your Honor, it goes
about the more central part.
The case law in this state and in other states that the state has relied on would suggest that if it just goes to the credibility of the witness, then that's not sufficiently exculpatory to justify a judicial interference with the executive decision as to who to prosecute in this case or other cases, Your Honor. What we have here is not only a situation where the witness's assertion of the Fifth or the right against self-incrimination has essentially trumped the defendant's right to present his defense. And that belongs entirely to the witness here. And there's no indication that any witness here would have possibly agreed to anything less than fully compelled transactional immunity, Your Honor. That was certainly never brought up, and no suggestion was ever made here. The other is so usually our case law is going to say that the defense then has really no standing to say that a witness with a valid Fifth, he can't complain if the witness decides out of an interest in justice or whatever to waive his Fifth. He can't complain if the witness is given immunity. That's the state of our case law. Now we're asking the court to take a step into what has traditionally been an exclusive executive prosecutorial decision in terms of who is going to be available for prosecution on the subject of this testimony, either now or in the future. And
you would say that
the
appropriate line to draw is if there was evidence, which I take it at the word. There is no evidence of this. But if there was evidence of prosecutorial overreaching or misconduct, that would be one thing. But if you don't have that, then it's completely up to the prosecutor. That would be your position.
Your Honor, I think that is entirely consistent with the selective prosecution cases that it recognizes in those cases that it is essentially an executive decision-making constrained by constitutional requirements, Your Honor. And that would just be then, that's the same thing here. The decision on who to prosecute, it does not turn on just the facts of a particular case. It turns on who the person is, how broad they might be, what might come up in testimony. It cannot be that just because a particular thing is expected here that a particular person deserves some kind of immunity for what may even develop in the future for being a basis for prosecution, Your Honor. The individuals in this case, there's an indication that in fact, both our witness and Monsieur Verdu were members of the Bloods, were part of a gang. For all we know, Verdu might have come in, not only testified that I mean, there was the possibility I raised earlier that he testified that he'd come in and say it was a shooting. He was the shooter. But maybe he'd come in and testify that this was a revenge killing for some prior shooting that he was involved in. I mean, there's really no limits on what could happen here. Now, there's no arbitrary application of the immunity process here. We had one witness who the law enforcement people could talk to, had ability to assess, who came forward to us, who gave us information on the critical issue in the case, who shot the victim. And that testimony, the critical issue, was corroborated by other witnesses who were entirely independent. As opposed to that, we have somebody else we're supposed to be accepting essentially sight unseen, no opportunity to see who they are, what they talk to.
You hadn't ever, the prosecution had never talked to Mr. Verdu?
Your Honor, I believe there was some statements. These statements are not part of the record in this case. The defense attorney indicated that his proffer of what he expected Mr. Verdu would say differed from those prior statements.
Mr. Thompson, let's focus on the sort of prosecutorial misconduct potential exception to the court stepping in and ordering immunity, and try to figure out where that might lie. I take it if there was evidence that the police had discouraged certain witnesses from testifying contrary to the government's star witness under the threat of prosecution if they did, might that be the form of misconduct that might warrant an immunity order?
Some of the cases certainly have indicated, some of the out-of-state cases have certainly indicated that. It's obviously sometimes a fine line there. I don't think it would be at all a problem for a prosecutor to sort of generally say, this witness may have a fifth, maybe he should talk to counsel, as opposed to somebody, the cases that have found prosecutorial misconduct are more on the line of someone was there available to testify and the prosecution goes out and specifically threatens, if you dare to testify, we will do this kind of thing. And I think that's along the line of cases that suggest that the prosecution cannot interfere with access to witnesses, to access. I believe that would clearly be a prosecutorial misconduct that could do that. Yeah.
Thank you.
So what would be the protocol if that were to happen? Would there have to be a request made by defense counsel to the prosecutor to provide immunity to that person, and the prosecutor would have an opportunity to explain why the prosecutor thinks that will not, or that should not happen? I mean, how do you put together a record for that?
Your Honor, I haven't. In mid-trial, it would obviously be difficult. It's a complicated issue. It's sort of like a suppression issue that would seem to need a whole entirely different hearing to go into this whole details of this with perhaps independent testimony and basically akin to issues on suppression. It would be similar to either a suppression of the Commonwealth's witness or what ultimately the result in some of the cases from out of county would be, from out of the jurisdiction, would be a new trial with, would be essentially a motion for a new trial with a new trial being awarded with either a grant of immunity to the defense witness or decide not to present the Commonwealth's witness who would be in opposition. Here, of course, it came up at the last minute at trial. And in fact, there is no record of anybody actually asking the prosecution to even consider immunity in this case.
So that means there's also no explanation on the record as to why the prosecutor chose not to give immunity to these people.
The possibility that testimony pretty much came up by the defense at the last minute in the trial, Your Honor.
Was there any statement on the record by the prosecutor in opposition to what defense counsel was looking for?
Your Honor, what happened here was essentially the defense attorney said, this isn't fair. They've been able to get immunity for their witnesses, and now I can't put on my witnesses. And the judge said, well, do you have any authority that would allow me to give immunity or to take any action in this case? And the defense said, no, I have no authority whatsoever. And that was about the end of it, Your Honor. The prosecution didn't get involved. It wasn't even asked to get involved.
So it was after, was Mr. Verdu and Mr. Stewart on the defense witness list to begin with?
Your Honor, I don't remember now. I know this statement was made at the end of the trial that Verdu had been expecting to testify, but had decided more or less that later on to assert his Fifth Amendment.
Did the two Martin hearings of those two, or the counsel for those two people, did that happen after the Commonwealth had rested?
Yes, Your Honor. It was after the Commonwealth arrested, after the defense had presented several witnesses, and after it was determined that these people had a fifth and weren't going to testify, the defense rested.
Did defense counsel make an opening argument or an opening statement at the beginning of the trial indicating who might testify and what they might say?
Your Honor, I don't remember any specific reference to Mr. Verdu or Mr. Stewart as part of that, though I can't say that with 100% sureness at this point, Your Honor. Your Honors, there is always a risk in granting immunity to anybody. There's always the possibility that he's going to testify to more than it's expected to, and that it turns out to have been a bad choice to give an immunity. It's always there. It's there when the Commonwealth does it. It's there when everybody does it. When the Commonwealth takes that risk, at least then, if it turns on us and it turns out to have been a bad choice, we answer to the public. We answer to the public, to the voters in our next election. It's part of our obligation as a prosecutor to do overall justice, to make just those kinds of decisions and take just those kinds of risks. Nobody else, not the defendant or the court, stands in that same kind of position answerable to the public that is entitled to make those kind of decisions.
You're not making an argument for elected judges, are you?
No, I'm not, Your Honor.
Thank you, counsel.
Thank you.